Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? Status of Forces Agreements, SOFAs, are designed to delineate the jurisdiction of military personnel and their dependents when stationed in a foreign country. On this episode of We Get Work, we delve into the intricacies of SOFAs and how these agreements apply to immigration, taxation, and other employment law issues for military spouses who want to continue working for their U.S. employer. Our hosts today are Chris Anderson, principal in Jackson Lewis's Greenville office, Michael Watts, of counsel in the firm's Los Angeles office, and Beth Boyer, associate in our White Plains office. Chris counsels clients in international employment law matters in over 100 countries. Michael is a judge advocate general in the U.S. Army Reserve and former U.S. Secret Service special agent. Beth advises businesses on how to secure work authorization and retain non-U.S. citizen or permanent resident employees. Chris, Michael, and Beth, the question on everyone's mind today is, how can SOFAs help U.S. employees maintain their positions while their spouses are deployed to serve or support the military? And how does that impact my business?
In today's podcast, you may hear the speakers express some opinions about military operations or military legal practice. These opinions are the attorney's opinions and are not reflective of the official position of the United States Department of Defense or any United States government agency. Thank you.
Thanks, Alicia. I'm glad to be here with my colleagues and friends, Michael and Beth. And I just want to give a quick introduction on myself, just my practice area, and then I'm going to kick it over to Michael and Beth to do the same. As Alicia said, my name is Chris Anderson. I'm one of the members of the International Employment Team here at Jackson Lewis. And for the past 11 years, I've been helping clients around the world solve employment problems on a global scale. And that's anything satelliting around employment we get involved with. And over the last 4 years, remote work has become a huge piece of that for me, generally speaking. So I just deal with a lot of U.S. personnel and other personnel from around the world who are going to another country and we have to look into the employment, the immigration, the tax, all those issues that surround that remote work. And one piece of remote work that I've particularly developed some experience with over the last years has been with what's called status of forces agreements, is what we'll call SOFAs in our conversation today. And it's where spouses of U.S. military members and or civilian defense contractors or other government subcontractors, their spouse is working for typically a U.S. company, and they need to go overseas with their spouse who's being stationed overseas or going on a government contract overseas. And the question becomes, how do I keep working for my U.S. employer? Or the U.S. employer comes to us and says, how do we keep employing this person? We love them. He or she is really great. We want to continue this. How do we do that? And so it opens up a whole host of issues that are fun to talk about, not always easy to figure out. And that's why we have Beth and Michael here today. So Beth and Michael, please take turns introducing yourselves, and then we'll go from there.
Okay, I'll start. I'm Beth Boyer. I'm an attorney in Jackson Lewis's White Plains office, and I practice immigration law. And I do the inbound work. So we've got Chris handling people that are dealing with global mobility issues. They're outbound. They're going all over the place. I'm helping U.S. companies bring people who are foreign workers into the U.S. And I also happen to be part of a military family and do a lot of military immigration work on a pro bono basis. So when we get some of these questions from our firm clients, hey, we've got this ace accountant and they're going to be moving to Yokosuka, Japan with their wife who's, a Navy officer, and we need to try to keep this guy employed. How can we do that? the questions would come to me because people knew that I had a military background and experience with military families. So it has broadened my practice to include not only the inbound work, but also this outbound, specifically related to spouses on a status of forces agreement or a SOFA.
Mm-hmm. Well, hello, everyone. My name is Mike Watts. I'm an of counsel in Jackson Lewis's Los Angeles office. My practice is mainly traditional labor, and I'm here today based mainly on, I do some work with the International Employment Team, but I also am a current drilling reserve U.S. Army Judge Advocate. I'm a lieutenant colonel assigned to a legal operations attachment in Nashville, Tennessee. And I started my career as an active duty Judge Advocate, or JAG, stationed in Germany, where I was working with spouses and also other contractors and contractors' families on these very issues of employment and spousal employment, and also other types of remote work, home-based businesses, which, back in my day when I did that was all selling Tupperware or, Mary Kay or Avon or things like that. And now has obviously changed a great deal in the past 20 years. So it's a pleasure to be here with everyone today.
Thanks, Mike. Thanks, Beth, as well. So you can see I have some heavy hitters with me who have a lot of varied and great experience with this issue. So glad to be together to talk about this. So before we go any further, let's define what a SOFA is to make sure that everyone who's listening understands what a status of forces agreement is. And then let's add to that, just to tack on to that, the issues that often arise from the SOFA and how it applies specifically to spouses of active duty military and or civilian government subcontractors who are going overseas, and that spouse wants to continue working for their U.S. employer. Who wants to jump in first?
Mike, do you want to maybe just say what a SOFA is?
Sure.
Okay.
So a SOFA, as you both said, is the status of forces agreement, typically called a SOFA. I'm very familiar, for example, with the NATO SOFA. So SOFAs can be either multilateral, such as the NATO SOFA, or bilateral, such as Beth had mentioned with the SOFA Japan. And there are also supplemental agreements that then supplement that SOFA. So, for example, I'm very familiar with the German supplemental SOFA agreement, which supplements and adds context and nuances about Germany's specific laws to the multilateral NATO SOFA. And again, these agreements are long-running treaties that were signed, in the case of the NATO SOFA back in the, mid-century and then updated, over the decades in the case of some of the supplemental SOFAs.
Right. And so what these SOFAs do it's a treaty between the U.S. and the country where we have military forces stationed, and it delineates and explains what the jurisdiction is for over the people that are going to be there. So, for example, a person who's stationed in Germany doing work, they're in the Army, they are working on base, they're going to be subject to U.S. jurisdiction, for example. But their spouse wants to work. Is that going to be permitted? Is that allowed as part of this status of forces agreement? And something that Mike indicated is that these were, many of them, written mid-century, most of them somewhere, in the decade following World War II. At that time, almost all spouses of military members were women, and most women didn't work. And there was no such thing as remote work other than, home-based sales perhaps. But, computers weren't in everybody's pockets. So we didn't have this kind of an economy that would allow for that. So now what do? The SOFAs, for the most part, are silent. These agreements don't say spouses can work. If they do, they are subject to local taxes or U.S. taxes. They don't describe what employment laws will cover them? Will it be U.S. employment law if they're working remotely from the U.S.? Will it be the Italian employment law if they're stationed in Italy? So all of these things are not in these SOFAs.
That's a great word, and that definitely crystallizes the issues here for all three of us, and the clients, you employers that are listening to this podcast, is the things that you're thinking is, if that's true what Beth just said, and it is, that the SOFAs are not drafted with that in mind, because that wasn't a reality at the time they were drafted. What do we do? How do we change that? How can the government change that? Is there any movement with that? And that's what we want to talk about now, is what we're seeing. We won't use the word trend necessarily, although we're seeing some positive movement in certain countries. But we wanted to speak about a few of those things and give some concrete examples, because this is an issue that, from my experience in dealing with this many, many times over the last 4 or 5 years, it's just something that many employers are thinking about if they have that person, that spouse, who they want to continue employing, and trying to figure out those things. If I could just lay out a few things, and Beth and Mike, tell me if you agree or disagree or chime in. But when I think about these issues, I think first and foremost on any remote work issue, it's immigration, and then you have to look at taxation and employment, and the application of employment law. Those are the big three that come up for me time and time again. And we're not claiming to be tax experts. We're not tax attorneys, although we get involved with tax treaties and those kinds of things. So we always want to disclaim that and say, seek some tax advice. But when you think about those three things, guys, and immigration, taxation, and employment, in your experience, how have you seen the SOFAs deal with those issues or not? And maybe more importantly, what has been done in any specific countries to address that lack of clarity in some cases?
Right now, there's only one country in the world where the U.S. has forces stationed where there's been a very clear update to the SOFA about this, and that's Italy, that signed a series of side letters. And again, this is, sort of an appended a document to this bilateral treaty that the U.S. has with Italy. And it's very clear. It says that a spouse working remotely from a U.S. company and present in Italy with this SOFA status is able to work. So they've got work authorization. They're taxed as though they're going to be in the U.S. And the employment laws that will cover are U.S. employment laws. And that's really important, because if you're in another country, let's say Germany, U.S. employment law will not be the law that governs that employment relationship. Is that right, Mike?
Well, yeah, and I think that's a great point. And it's, for me, coming from my particular background, Chris, you highlighted how we think about this, advising, our clients and also other potential clients that are employers. And my experience is the flip of that is advising the employees who would come to me as a legal assistance attorney and say, I want to work for this particular location. How do I go about doing that? Or I want to start up a home-based business, which now is much more likely to be a remote business. And I think either way, as a judge advocate and as a military professional, I'm trained to think in a very flowchart-esque manner. And one of those issues is, what's their status? It's very similar to the question that we would ask about potentially, for example, a prisoner of war. What is their status? And that's the question also for an employer who's going to potentially send a employee forward. What is their status? Are they going to be working? Are they going to be living on post, working remotely for a U.S. company? Is that U.S. company headquartered, here? Several of the employment laws talk about various tests for the employment law perspective, Beth, that you're talking about, of, is it the center of gravity test that we're going to apply? Is it the primary workstation test that we're going to apply? But what are they doing and who are they doing it for? And so, for example, if you are a U.S. spouse stationed overseas working for AAFES, the Army and Air Force Exchange Service, which is a quasi-government organization, and you're working on post.
I'm glad you defined that. I didn't know what that was.
The PX.
Well, the PX, exactly, which is the post exchange.
Yeah.
Of course, wouldn't be a military podcast discussion if we weren't speaking mostly in acronyms. If you're a spouse living on post, working on post for a quasi-government organization, then that's one set of facts, Beth. Whereas I've definitely dealt with spouses who either wanted to work on post for German companies that were permitted to work on post, even down to as small as the local barber who has application and has an approved application as a German citizen cutting hair on post, versus working for, I've worked with spouses who wanted to work for German versions of defense contractors who are working on American posts. So I think that's the critical question that you have to answer and you have to look at is, who is going to be doing what work, where, and for what type of employer? And from there, when you start with that framework in mind, then you can look at the German supplemental agreement, for example, and see, okay, are they going to be paying only the German taxes for the work they perform in Germany? And as for example, if they fly back home and work back home and then fly back to Germany for a period of time, the Germans and the tax treaty and the German SOFA treaty might then deal with those incomes very differently. So right. It can create a kind of a whole host of issues, but starting from that analytical framework, I think is where we always have to begin.
Yeah. And that's a great word, Mike, just because I like that you said that you have to start with what are they actually doing in the country. And Beth, you alluded to it as well. And there's just a phrase we use a lot when we advise clients on this, and it's, are you working on that economy? Are you engaging that economy? And that could be, as Mike just said, through a subsidiary of the U.S. company. And maybe a client comes to us and says, this spouse wants to go to Germany or to Korea or Japan or any of the countries that have SOFAs with the U.S., and they want to go. But we have a subsidiary there, and while they're there, they can have a seat in that company, and that's a bit of a different analysis in many ways versus the classic example that I get of many of my clients, and maybe you're listening, thinking this now as well. We don't have any international operations, or we definitely don't in that country, but we want to know how we can continue to support this all-star employee, this wonderful employee that we have. And if that's the case, now, while we can't say hook, line, and sinker, it's always fine by any means to just keep employing someone remotely when they're a spouse of a service member or civilian contractor of the government. You need to look at each country, and I think we all agree on that. But the SOFAs do speak to it increasingly, like Beth said, with Italy, with Germany, with the supplemental agreement that Mike just referred to. There's language in there that makes it at least more clear on the immigration side that you wouldn't have to have a work permit in Germany if you're going to be doing remote work. And if you're paid in US dollars, then you would be able that your employer wouldn't have any taxation duty in Germany, but you would have an individual tax duty. The person would have an individual tax duty in Germany. But that's just one example. And then German employment law that Beth alluded to as well and spoke to, we can't say definitively that it wouldn't apply. I have some clients of mine, and Beth, you and I think have talked about this in the past. Some of my clients have said, we're just going to take the position that U.S. law continues applying. And you can do that. If you're listening, that you can do that, but you need to understand that if challenged, German labor and employment law and the minimums that apply statutorily could apply. And so you just need to be aware of that. And I think awareness is at least part of the battle, if not half the battle here, is just being aware of what those risks are. And that's where we help clients. I want to kick it back to you guys. And Beth, can you speak to to Japan just briefly. And again, just one caveat to our listeners. There's many, many SOFAs. We'd love to talk to any of you about SOFAs and how they apply. It does need to have a case-by-case analysis. But when I think about these, and we all agreed ahead of time, Italy has the most clarity now. Germany, as we've alluded to, has the supplemental agreement that provides more clarity than some other SOFAs. And then Japan is the third one that we wanted to raise. So Beth, I'll kick it back to you.
Sure. And I just want to preface by making one point, because this is something that comes up quite frequently when an employer calls us and says, I've got this issue. They tell us, my employee is going to be living with their spouse on base. So that's U.S. soil, right? And so we don't have to deal with any of this. And so I just want to make clear that living on a base does not constitute U.S. soil. This person is still overseas. They're in the jurisdiction of this other country. And that's why all of these analyses need to be done, because even though it's a U.S. military base and they're married to a U.S. military service member, they still have to abide by the laws in that country, subject to this bilateral agreement, the SOFA. So with regard to Japan, now a lot of these, where there has been some discussion about or some clarification about what the rules are, it's hard to find many of these. And the guidance to military dependents about Japan, you got to do a little digging to find this. We got this one through a little bit of a roundabout way. There was a woman who was posted to Japan with her husband. She wrote an article on LinkedIn. Chris and I actually started communicating with one another about this. I'm looking at the chat 3 years ago. It was before Chris was at Jackson Lewis, and
right.
we were communicating because we both had clients that were dealing with the SOFA issue in Japan.
Working very collegially there.
Yeah, absolutely. And then here we are together at the same firm doing the same thing, because we all need to try to figure this out. So remote work, a dependent with SOFA status in Japan is allowed to work according to this this military clarification. This comes from the Air Force, but it's valid for whether you're posted at Yokosuka or you're with the Army or the Air Force in Japan. It's going to cover everyone. Taxes, if you don't derive your income from a Japanese source, you're not going to be subject to Japanese taxation. But it is silent on employment law. So it addresses the two big questions. Can I work? Yes. Do I have to pay taxes in Japan? No. What employment law is going to govern my relationship? Am I going to be subject to Japanese rules is my employee? This is often what the employers want to know. Are we going to have to follow Japanese laws with respect to leave, promotions, sick pay, things like this?
Right.
There's even the new publications from the Department of Defense don't speak to that.
Right. And that's a trend. I'm so glad you raised that, Beth, because that's a trend that you see a lot of times. And as an employment lawyer, it causes great consternation for me, because I want to have clear answers to give clients. And the client 3 years ago, Beth, that I was advising at the time that you and I collegially worked together, and both reached out to this individual on LinkedIn. That client, they ended up taking the position that U.S. law applies. However, like with Germany that I just mentioned a few minutes ago, we had to say eyes wide open. You have to know that if challenged, and that would typically be the person, him or herself, bringing a claim, which the client then said, well, that's probably not likely. And that's probably true. But if it ever happened, you have to know that that chance is always there. In the absence of definitive status on that, or a definitive stance from the country or through the bilateral agreement, there's at least that ambiguity, that wiggle room that can be exploited. And so you just have to be aware of that. And then you get into how long are they going to be there? What are they doing? Which country has a greater connection to the work? I mean, all these host of things, and every country is different. And so it has to be a case by case basis, which as attorneys we say a lot. But any closing thoughts, Mike and Beth, before we sign off?
I would just say, I think, Chris and Beth, as you both pointed out, no one's ever going to be able to give you a shield that you're going to be able to take to the German authorities and say, this is the locked in 100%, answer to this question. And I used to do that from the client perspective of, I would write letters to their hopeful employers, or to them, or to the, other, even, sometimes to the German authorities, saying this is why the SOFA applies this way. And again, I've worked with a lot of German attorneys in Germany who say, this is our perspective of German attorneys as how the German law would apply. But, Chris, as you pointed out, so for example, the German, mother protection law is very different than the American protection law, or FEMLA. And if an employee wanted to raise that could be a big issue for an employer. So that is definitely something you do just have to go into and with the eyes wide open of what do we think is likely versus what is the kind of worst case scenario. And then that goes to the risk analysis of, do we want to continue to employ this, this all-star accountant who's going to go forward, with his or her family. But these SOFA issues and these employment issues are so critical to the military community. Being a judge advocate, we have pressed very hard in our community for laws and even state laws and other laws that spouses are able to practice their professions, specifically the legal profession, wherever they are stationed in the continental United States, or outside the continental United States as well. And being able to work with your spouse overseas is a huge recruiting and retention issue. And that is America's military's number one issue right now, is maintaining a force that can achieve the national security goals of the United States. And so that's why it's so critical for employers to feel comfortable to say, there are solutions to these problems. We just have to get there. And there is a way to go into this risk eyes wide open. But I had a friend who had left working with my wife at her location and went with that spouse forward to Japan, and had to leave her job and go forward to Japan. And that was not a position where she could have worked remotely. But this impacts, Beth, I'm sure in your military spousal community, this impacts families every day. This is not some remote issue that esoterically kind of comes up, once in a blue moon. So it is definitely a huge issue.
Yeah, absolutely. And what happens with some military families is if my spouse isn't going to be able to work,
right,
and that means that half or more of our family income is going to disappear, maybe I don't re-up. Maybe I resign my commission and I leave the military. So as Mike said, this is a retention issue, and military retention is not what it needs to be. And recruitment is not what it needs to be. So retention is that much more important. So hopefully, to the extent that's possible, we'll see more side letter agreements like Italy's getting negotiated between the Department of State and Department of Defense and the countries where these folks are located to clarify these issues on the SOFA, because this just was not anticipated. It wasn't. It wasn't even a possibility at the time that these agreements were originally signed. So in the absence of that, Jackson Lewis attorneys are here for you. We'll look into it. We'll let you know what the deal is, and if there are risks, try to quantify them for you and help you to make the decisions that you need so that you can keep employing the people that you want.
That is a great final word, Beth. And Mike, thanks so much for joining and doing this with me. It's a pleasure to be with you guys. And to all of our listeners, thanks for listening. And as Beth said, please do reach out anytime. We're here for you, and we appreciate you listening. Thanks so much.
Thank you.
Thanks.
Thank you for joining us on We Get Work. Please tune in to our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.